Welcome. We're going to introduce ourselves. So, Andrew, go first. Go first.
How you doing, everybody? I'm Andrew Jaloza. I'm the principal attorney at the Estate Planning and Elder Law Group. We're a New York firm. We do estate planning, elder law, asset protection, and real estate. And we're here to with Evan and Dean to talk about how real estate and estate planning go together.
And my name is Dean Graver, and work at Team NWE, Keller Williams Realty. Evantz and I are realtors, business partners at Keller Williams. We're located in Bayside, Queens, and we decided to put this together because we saw throughout the years and throughout all the time we're dealing with different clients, how much of a need there is for this conversation to be had. And Evantz and I work in Brooklyn, Queens, Bronx, and Long Island. And I've been in the real estate business for 11 years, and I have a history in the mortgage business before that.
And I'm Evan Saint-Gerard. When I'm not lip syncing, I'm a full-time real estate agent. As Dean said, we work as a team. We have our other team members here in the chat as well. We're, like Dean said, real estate agents full-time. This is a difficult conversation people don't like to have. Unfortunately, like Dean said, we see this a lot, and had people had these conversations, put plans together, they would avoid a lot of the messes that we see. And we hope that you guys get some stuff out of this. And we're here to, make ourselves available to everyone. So if you have any questions, there's no dumb questions. We're here to answer your questions for you. And if you don't have a question right now, if something pops up later on, we're always available. Just gonna start off with, I don't know if you can see my QR code up here. If you're watching on your computer and you happen to have your cell phone handy, just turn on the camera, point it to the QR code, and you'll have my contact information. Also, I think at some point during the seminar webinar, our information will be sent out to everybody, or you'll get an email later on as well.
And as far as the process tonight, we have 5 topics that we're going to be covering. We say most of them are going to be from Andrew because it's related to probate and estate planning, and then Evans and I are going to talk about how this affects real estate planning and running into smooth closings as opposed to non-smooth closings in real estate matters. So with that said, Andrew, you want to start off?
Well, before Andrew starts off, I just want to give a little house cleaning. If you have any questions, we have the Q&A button on the bottom of your screens. Just click on that, type in your questions right there, or use the chat to write your questions. Also, if you'd like to say something, hit the raise the hand, and then, one of us will get back to you as soon as possible. Andrew, the floor is yours.
Thank you so much, gentlemen. Yes, it's really great to be here tonight. And so we're going to talk a little bit about what probate is. Many people come to my office and say, I need to avoid probate. And I say, oh, good. Tell me more about that. What do you mean? He goes, I don't know. I know I read in the newspaper. I see it in the magazines. I see it, Susie Orman on television. And everybody says I need to avoid probate. I don't really know why, but I think I want to avoid probate. So we're going to talk a little bit about what probate is. And by the time we finish the conversation, probably you're going to want to avoid probate too. So probate is a process that takes place in the surrogate's court. And probate is technically an overall name. Usually most people refer to probate when you have a will, and they call it administration when you don't. Both of those processes are about the same. The major difference is when you have a will, at least you get to choose who gets your property. When you don't have a will and it goes according to the process called administration, the state rules, the laws of intestacy, decide who gets the property from your estate, which is very important, especially if you own, if you want your property to go to a specific person who is not what, part of the traditional family tree. So in other words, when you live together with somebody for 40 years, have 5 kids, you call each other husband and wife, and you're not legally married. When you die, your house does not go to that person who you call your wife or your husband. It goes to your children, because those children are what we call your distributees. Those are the people who are entitled to take by law if you are not married. And if you're married, then you want everything to go to your wife. If you just don't have a will, what's going to end up happening if you don't own it by joint owners with right of survivorship, then what happens is if you die, your kids get half the property and your surviving spouse gets the other half of the property. Most of the time, that's not the way you want it to work out, but that's the way it works out if you don't have a will. So the will, what many people come in and also say that I have gone to an attorney and I have a will, I get to avoid probate, right? The answer to that is, like, when you hear on the Family Feud, when the answer is wrong, well, it's wrong. Because what happens is that when you have a will, in order for that will to go forward and for the executor to have any power to do anything. So you name it, let's just define what a will is quickly. A will is a document you create. It has a person you name as the executor. They're in charge of gathering your assets and passing it on to whomever you want as you set forth in your will. And so you choose your executor, you put it in your will, you say that it goes to Joe, Sam, and Bobby. The executor cannot do anything until the court says, executor, you have the court's authority to move forward. And that's how the probate process starts, by taking the original will and filing it with the court. That process is a public process, meaning that anybody who wants to go into the court's records, either, now it's online, it's not even difficult to get there. It used to be, you had to go down to the courthouse. It's online, you can see everything that's going on there. And so this process, number one, there's a gigantic delay in the distribution of your assets. You want things to go to your family quickly? It's not going quickly because the executor first has to get approved by the court. If anyone disputes it, now you're in a whole big fight. Property is not being distributed out for even longer. It also requires a publication so that creditors can be notified that someone died and they have the right to come in and make a claim. The problem when it comes with real estate and the probate process is you may want to sell that house immediately, right? So you have a bunch of siblings, all of you own it together. Bigger problem when one lives there and he doesn't or she doesn't want to get out and everybody else wants to sell the property. I mean, it comes with these pitfalls. So the point is it takes more time, more effort. It costs more money to go through probate. And until you get the authority from the court in the form of letters testamentary, no one has the authority to sign a contract legally on behalf of the estate to sell a piece of property. And sometimes, especially with administrations, the court will limit the power of the administrator or the executor by issuing limited letters of administration or limited letters testamentary, which says that the court, no real property can be sold without the court's permission. So you can't even enter into a contract technically without the court agreeing to. So probate and real estate, often creates this situation of frustration and expense, certainly delays, that is avoided by, say, using a trust. So the probate process is necessary and basically has three stages. One is getting the authority for the executor. Two is getting gathering the assets once the executor is appointed. And then three is distributing everything out to the beneficiaries, including selling the real property and doing other things. Dean, you have your hand up.
I actually do. I want to learn as much as everyone else here. I have a question. You have a will. You've done a will. Let's say somebody did it at home. They did it more, online. And it's sitting in your house. This might be a true story. How does that count as a will? If it was notarized and signed, does it actually have to go somewhere to be a will? You know what I mean? To be acknowledged, let's say.
Well, that's a great question. So in New York, there are certain formalities that are required of a will. In other states, you can write a will on a napkin. Some places you can actually make an oral will, just say your wishes, like the last dying declaration and things like that. In New York, you have to have a couple of things. It has to state the fact that you're making this will. It has to state the fact that you believe you're of sound mind. It has to be signed in front of two subscribing witnesses. The notary part, there is no real notary requirement for a will. Okay. When you see a will that has a notary, it's because the attorney who drafted it also did an affidavit. They took the affidavit of the two witnesses who attest to the fact that they saw the testator, the person who created the will, signed the will in front of them. They believed he was of sound mind. He declared it to be his last will, and he signed it in front of them. And that affidavit is notarized.
Thanks.
And if all of those things are there, then it's a will, whether there's attorney involved or not. The problem we see quite often is that, like LegalZoom, for instance, and I'm not saying LegalZoom is bad. I'm just saying do it yourself has the very significant chance of not being correct. And when it's not correct, when do you find out? When it's too late to do anything about it. That's the problem. So it's not, do it yourself is do it yourself. And I see a lot of times I've seen, here's a real story. Person came to me, has this will. It was two gentlemen who lived together for 40 years. One of them owned a $5 million co-op in Manhattan. He left it to his partner, brought this will. It was not good. It was not signed properly. That property went to the decedent's second cousin instead of to his partner. That's what happens when you have a defective will. You have no will, and that creates big problems.
Okay, thank you.
Any other questions about the probate process? The process timeline. Let's get a quick follow-up. Number one, if you email us, we will send you something called the probate timeline. And so that will be a follow-up, something that you can send us an email about to receive that. But the probate process at this point in the city of New York takes approximately 2 to 6 months to get letters, just to get the letters so that the executor or administrator can do anything. And from beginning to end, the process usually now is taking somewhere about a year to 18 months, if not more, to get all of the property and then to distribute it all out. That's a lot of time. So
this also varies basically from counties to counties, right?
Well, we have what we call in New York the unified court system. I can tell you it's not unified. It's a court system maybe, but so not unified, it's amazing. Every county and every clerk, it seems, has different requirements. It really is. It's funny almost that it's called the unified court system and how differently it's all handled. How do you avoid the whole thing? Use a trust rather than a will. We'll talk a little bit more about trust as we move forward our conversation here.
So I have one more piece. This is very interesting to me. Somebody has a will, and let's say it's not a legal zone. Let's say it's a regular will. It passed away. Who's paying the property taxes, the maintenance on or the upkeep of a home for 12 to 18 months? What if that home is vacant? What if it was a mom or dad and everybody is actually just gone from the household?
That's a problem. It really can be a problem because the executor really has no authority. So, for instance, there's two problems you have with a will and and a vacant property, right? So, number one, where can you get the money from? No one can touch the bank accounts. The bank accounts that are in the decedent's name are all basically frozen. You can't go there and say, "Hi, I am the son. I'm named executor. I need to get some money out of there to pay the bills for this house." You can't touch the money. Not until you get those letters, those authorization from the court. Number two, who's going to pay it? I mean, the beneficiaries generally will gather to pay it because that's going to be their house. And so they're preserving it. And the thing is, if they don't pay it, what will happen is eventually, the city will sell the tax lien. If the real estate taxes are not getting sold, you have another issue to deal with at the closing because now you have a tax lien sale and you're paying the Bank of New York who buys these tax liens, and you're paying them interest at exorbitant amounts, and you're paying interest on every single day that they have this tax lien. Or they foreclose on the tax lien, and they seek to take possession of the property. So it is a dicey thing, but like the beneficiaries will figure out a way most of the time to pay those taxes or pay the bills for the house to make sure they preserve that asset.
Okay.
So I guess the next subject is there anything else you want to add?
The next subject is how to sell a property from a living trust. So first of all, what is a trust, right? People hear trust and then use trust rather than will. Well, a trust is a lot like a little red wagon. You guys have a little red wagon when you were kids?
I'm going to say yes. I'm speaking for the audience. Yes.
Everybody,
Speaking for a friend.
everybody kind of smiles when I say that, and it's kind of funny that I bring up a child's toy in a serious conversation. But using this little red wagon analogy is a very clean and easy way to describe what a trust is. So think of all your assets as gift wrap boxes, right? You have a gigantic box for your house, a smaller one for your car, tiny ones for your bank accounts, and you're kind of walking through your life carrying all your boxes, right? So what happens? You die and you leave a will. You die, you fall down, the boxes go all over the place. Who's going to pick up those boxes? Well, you want the executor to pick up the boxes, right? But the executor has no power until they take that will, go to probate, and get the permission from the court to pick up those boxes. Like you say, there's expenses to pay, the water bill keeps going, the tenants are there, who's collecting the rent? There's a whole bunch of issues involved when you own a piece of property in your own name and you leave a will. There's issues involved in the timing of the person being named the personal representative of the estate, the executor, to take over and do the things they have to do. Rather than carrying all this stuff, stick it into your little red wagon, this little trust you create, right? So you then walking through, pulling the trust, your little red wagon, you fall down and you die. In your trust, you've named your successor trustee. It says that in the event that I get really sick or I become disabled or incompetent, or if I die, then I appoint my son Jim. He's going to be my trustee, and I want Jim to make sure that if I'm sick, that make sure you plan for me to protect me against long-term care costs eating up my whole estate, and also make sure that my wife's new husband doesn't get my money. So you can put all of these plans inside your trust, and it says, when I die, what I want you to do is sell the house and split it between my 3 children, right? And so you created this document, this trust agreement, that's kind of like this box you create, and that's what you put your property into. So you take your property and you fund it into the trust by making the trust the owner. How do we do that with real estate? We do a deed from ourselves as the owner and to ourselves as the trustee of the trust, because usually we're also the trustee of our own trust. So if we're the trustee of our trust and we die, there is no court process. There's no probate process. There's no waiting for documents to come out of the court to authorize us to do anything. We have the power to deal with our property. In addition, here's another thing where probate and real estate are an interesting mix, because when you own your property in your own name and you own it in several different states, if you die having a will, you not only have to do the probate in the state in which you died, you have to do a probate proceeding in every state that you own property. Which means if you own 5 properties in 5 different states, you're doing 5 different ancillary probate proceedings in addition to whatever it is in the state that you died in. So how do you avoid that? You put all of them into your trust.
Is it one trust?
You can make it one trust, you can make it several trusts, no matter what. Those trusts, say we live in New York and we have 3 New York trusts because we want to keep our properties separate, then all 3 of them will get dealt with under New York law wherever you're living, and it will never have to go into any court to probate it, because that's the nice part of having your property in a trust. Evan.
All right, we have a question from Claire. She wants to know, how much does it cost to create a trust?
Well, it depends. There are different things. So that I can tell you a general range is somewhere between, say, like, $2,500, $3,500 to $10,000, depending upon what your trust is doing, whether you're doing it to do asset protection and things like that as well. But you can a revocable living trust, you're figuring somewhere between $2,500 and $5,500, depending upon what planning and how the levels of planning you're doing. But then generally speaking, that's what I think an average cost is. But think of it this way. If you're saving the probate costs of going into 4 states, and you're doing it in something that you don't have, the people who will take over from you have your rules in a self-settling document that you get to put all your rules in, that's really saving so much money in the future. So you're paying a little more than a will now, but saving a lot later.
All right. Thank you, Andrew.
So the question was, how do we sell a property from a living trust, right? So
Right.
what is a living trust? So there are two types of trusts. You have testamentary trusts and you have living trusts. So I can create a will that, it's like, let's say I want to set a rule that I have a son, every time I give him $1, he spends 5. So when I want to give him some money, there's going to be some controls over it, right? How do I control something in the future? Well, if I give it to him outright when I die, then he owns it. He can do whatever he wants with it. There's no control. There's no plans for it, right? How do we do plans for it? Our will, upon my death, will create a trust for my spendthrift son, who every time, like I say, every time I give him $1, he spends 5. So I now put his sister, the strict one, in charge of his money and say he gets X% every 5 years, he gets $100 a year, he gets whatever. I make those rules that go into effect when I die. It has to be probated because it's a will, and that's why it's called a testamentary trust. A living trust is something you create while you're alive. Like I create a trust while I'm alive for my family. I call it the Jaloza Family Living Trust, and it's in effect when I create it. All the rules apply today. The rules that happen after I get sick apply when I get sick. The rules happen when I die apply when I die. And no one has to be involved. There's no publication. There's no going into court. There's no filing the trust anywhere. Nobody has to know anything. It's private. It's faster. There's less expense and there's less headaches. So how do we sell it out of the living trust? So now I've died and my living trust owns this property. Now my trust is irrevocable because once I die and I'm the grantor, the owner of the property, that trust is now irrevocable. Nobody can put any property in. And then the rules of how it gets distributed are set forth in the trust. So now we get the realtor. Dean has the listing. He puts it up for sale. And so the contract gets created. The trustee of the Jaloza Family Living Trust owns the house on 123 Anywhere Street, and little Jaloza is the one who's going to sign it, right? So little Jaloza signs the contract as trustee. That's countersigned by the buyer. The process of mortgaging and whatever goes through, and at the closing table, the trustee comes as the trustee and signs all the necessary documents. The money goes into an account in the name of the trust and is distributed as the instructions are given in the trust. So how you sell a property from the trust is really not really any different than you sell it as an individual, because there is an individual who's named in the trust who's going to be in charge of doing that. Does that make sense?
We do have another question from Shauna. She wants to know if there's more than one person on the deed of the property. What happens if that one of those two people passes away and there's no will? Is it automatically now 50-50?
A great question. So real estate is owned in several different ways. So you can own real estate as tenants in common. So let's talk about two owners only, so it's an easier thing to think about. So two people own a property jointly. They own it by the designation of tenants in common, or they don't have any designation on it at all. It says Joe Smith and Sam Smith own this property. Sam Smith dies. Tenants in common means that each of the people who own it own a half of the property. And when they die, each has the right to transfer their half to their heirs. So that means that if Sam Smith, who died, he has little Billy Smith and Bobby Smith, those are his two children, he has no wife and he has no will, then that his half goes to the two little Smiths, okay? So that it just passes by operation of law along the family tree. If you have a will, it would then, his half would go to whoever he named in his will to get his property. That's tenants in common. The other way to own property is tenants, joint tenants with right of survivorship. So if if the Sam and Sid Smith own the property, joint tenants with right of survivorship, Sam Smith dies, Sid Smith is now the owner of the entire property. The surviving joint tenant owns the property 100%. It does not go to Sam Smith's children. The property upon death goes to the surviving owner. Now, the difference between when two people who are married own a property together and the people who are not married or own the property together with survivorship rights is, as a joint tenant with right of survivorship, with my brother, with a stranger, with whoever, I can sell my half of the property still. It's still subject to that right of survivorship. But when a husband and wife buy property together, the joint tenants, the husband cannot sell his interest without the permission of the wife. So there are three different ways to own property, depending if you're married or not. There's three different ways. If you're not married, there's only two different ways, which is tenants in common, mean you pass it on to your heirs. Joint tenants right of survivorship, the property goes to the surviving owner when one of them dies. So I don't know if that answered your question, but if there's any follow-up question, I'll be happy to answer that too.
I think you're good, Andrew.
I see that there's a question in the Q&A.
Oh, wait, something just popped in. 1 second. What's a good way to protect your real estate asset and to keep your personal name anonymous to avoid potential lawsuits?
Well, what a lot of people do is they'll own a property in an LLC and put an LLC in a trust. There's various different, levels of ownership into different types of entities to have anonymity. And the way to protect your assets is, use an asset protection trust. If you put your assets into an asset protection trust, you can protect against all future claims and creditors here in New York. And that, if something happens that someone sues you at some time in the future, that, for something that happens after you put your property in the trust, whatever properties in the trust will not be a subject of that lawsuit. They cannot collect their money from that. So, using layering in planning is one of the directions, including using asset protection.
Should they be advised to speak to their CPA regarding the LLCs and whatnot?
Well, I think that it's important that they understand that the difference of owning something in a different entity changes a lot of things. And
Okay.
so, when you're dealing with property and you're dealing with ownership and you're dealing with taxes, you really should get a qualified professional to give you some advice about it, because it definitely could have some distinct issues. Like, for instance, one of the things that is left in the tax code for everybody is what we call a step up in the cost basis, right? You get appreciated property in your family. How many people do you know bought their house 30 years ago in this area, paid very little, and now the house is worth $1 million or close to $1 million, right? And these people have this appreciation that technically is subject to capital gains tax. Because, you have to pay tax when you make a profit on something and you hold it for more than a year. It's called the capital gains tax, versus ordinary income. When you own something and you sell it within the year, then it's ordinary income and you pay ordinary income tax. So, there's very few great things in the tax code for like regular folks in this world. You have to have like 900 lawyers like Amazon to figure out how to really take advantage of the tax code. But for everybody who has appreciated property, whether it's a piece of real property or it's a diamond or something like that, the way that you pass on that appreciation tax-free is not to pass on your property until you die. Because when you die, that cost basis, what you own the property at, steps up to the date of death value. So in other words, if I paid $100,000 for a property 25 years ago, and it's now worth $1 million, that's $900,000 in profit, right? If I were to sell it, if I lived in the house, and if I say I was married and lived in the house with my wife for at least 2 of the 5 years before I sold it, I would have a tax exclusion of $500,000 for my primary residence exclusion. So I would only have to pay tax technically on $400,000 instead of the $900,000. But if I pass the whole property to my kid, he owns the property at the same $100,000 I paid for it. He doesn't live there. He has no tax exclusion. And if he sold the property, he'd have to pay tax on that $900,000, all of it. Tax on $900,000, capital gains tax on $900,000 is 25 to 35% of the $900,000 in profit, which is a lot of money, right? How do you avoid that? Is you don't pass it on to your kid until you pass away. When you pass away, they would own the property at the $1 million it was worth when I died, and they sell it for $1 million. Now we've passed on in the family $900,000 of appreciation tax free. It depends what type of trust you use. It depends how you make the transfer. But the point is, that is one of the last great things that they have in the tax code. So you need to make sure you're dealing with a qualified professional when dealing with your stuff to make sure that you preserve those kind of things. Because what happens is, a lot of people think we can do a deed transfer as part of our estate planning tactics, right? And it's probably the least expensive way to do some estate planning, right? Transferring the deed out of your name into your kids' names. And now if you get sick, then they can't go after the house after a certain amount of time, right? It still is subject to the same look-back periods for Medicaid when you transfer the house with no consideration for your kids. So you may mess up your planning for long-term care costs if you do it that way. But say you do it the right way and preserve what's called a life estate. Because I mean, yeah, I'm sure that you gentlemen have seen a life estate deed, right?
Yep.
Life estate deed is when I transfer property to, say, my child, and I reserve for the rest of my life the right to live in the house and make whatever decision. So basically, it only says I reserve a life estate. What that does is, since I withhold part of that, and I still own that, that when I die, that extinguishes, and then upon my death, my child has 100% of the property. It at least protects me in the property, that they can't really do anything without my permission. Because how many other stories have you heard when the parents transfer the house to the kids, and then the daughter-in-law says, no more planting flowers at my house to your mother, you know, or they throw the mother out and they move in and live in the house. All kinds of crazy stuff happens.
I wanted to comment on, you said, how many stories have you heard? I mean, that, if I can use that just as a little bit of a segue into why we're here also.
Yeah.
I find out a lot of families haven't heard the story of what the parents had in mind for them, you know, the kids, or the kids don't know, or the parents never had anything really in mind. Whatever they had in mind was not how things work. Like what Andrew just said, how you might have to pay tax on, let's say in the example he used, on $900,000 in profit versus $400,000 because of the exemption. So it's not knowing, not planning wrong, all of these things. But I run into not knowing. I run into people that I want to sell my house. Yeah, mom and dad had it. I would always ask you to have a will. And I mean, I'm learning just like you guys here are learning. And but I knew that, you know, we'd ask the attorneys, the real estate attorneys would say, ask if they have a will. All right, so I'd ask if they have a will. And but we didn't really know that meant that, okay, so we have an 18-month process here. And how that affects the sale in real estate is, I mean, sometimes we want to put it, or seller wants to put a house out to the whole public. Everybody who can afford the home is eligible to buy the home. And when we have a wait of 12 to 18 months, it's not everybody out there. It's everybody who's living with their parents right now and can stay at their parents' house. It's everybody who's renting month to month, and they're sure that their landlord will allow them to stay there for another 12 to 18 months to lock in today's real estate price. Who knows where the value goes tomorrow, whether it's good or not good, you know, for mortgage purposes, run into problems. There's so much unknown about not knowing. And I know that sounds simple, but it's kind of incredible that the plans are not out there. So for me, hearing about these, you know, what Andrew's talking about, I know I want to do some things for myself. I think that, you know, we just want to offer it out there so that less people run into less problems with the transfer of family real estate and their real estate. And a lot of
And,
times,
and
yes,
assets.
yeah, and the assets, and it's not just for the parents to do with the kids here, it's for the kids to do. I mean, tell me if I'm wrong with this, but someone's 30 years old, they want to buy their first home. I mean, I would just imagine, anything can happen to anybody at any time. It's usually better to plan in advance as a general comment for anything that you're doing. And I think that even just having the conversation about what to do with this, you decide on the time, but you can't do something after the fact. That I do know.
Yes,
That's
we
the
do.
real estate piece of this that I wanted to share as a general, what comes up.
We do have a couple of questions. One of them wanted to know if this seminar will be recorded. The answer is yes. The second question, will banks be okay for you to transfer the deed into a trust while you still hold a mortgage?
That's a great question too.
That really is.
So this is I'm going to give you two answers to this, because there's the way it happens in real life most of the time, and the way technically it's supposed to happen. So there's a law, it's called the Saint-Germain Act, and the point is they cannot say anything about you putting your house into a revocable living trust, right? So that law prevents them from doing anything, because if you have a revocable living trust, you are the same. It's like an alter ego, right? You're still the owner, and you're still the mortgagee. You owe the money. When it gets to irrevocable trust, it's supposed to also apply for irrevocable trust, but most banks get very wonky when it comes to irrevocable trust, because it's not exactly the plain vanilla that they're expecting. So what do you do about that? Well, you do about it, you listen to the experience of the people around you who will say this: if you're paying your mortgage every month and you're always on time with your mortgage, the fact that you're going to do an estate planning transfer is not going to make the bank force you to repay their loan, or say that you're not allowed to do it, take it out of the trust. And that's what most people do. They make the decision between the benefits of having the house in the trust versus the small, tiny possibility that the bank is not going to like the fact that they transferred the deed from themselves and into their trust.
We have a follow-up question to that question from Claire. She wants to know, can you refinance that property refinance a property that's already in a trust?
In a revocable trust, like I say, most lenders will deal with that and are prepared to do so. The difficulty with houses that are in irrevocable trust is the difficulties for the lenders to sell their mortgage into the secondary market, right? And that's where it comes with that service their own paper. In other words, the lender who issues the mortgage is going to hold that and collect that mortgage throughout the life of the mortgage. So they make the decision. And so there are lenders that do that, and those lenders do have programs that lend to irrevocable trust. So the possibility is, yes, you can. It may not be so simple if it's an irrevocable trust, but still possible. With a revocable trust, yes, you can.
All right, I think we're good with the questions. We're at 7:12 right now. So you want to follow up with the next subject?
Sure. I mean, I think that Dean touched on that, how probate affects title rights and closings, right? I mean, it is a surprising thing to understand like how different that is when your property is in an estate than when it's in your own name. So another reason why, if you have real estate, it's a good idea to have estate planning for it, right? Because, I can't tell you, the statistic is almost 70% of all people who own a home don't even have a will. And you think about that, the possibility, they buy life insurance, a lot of them, because now you bought this house, you have a mortgage, you want to make sure that God forbid something happens to you, that that mortgage is not going to choke your family, your family's not going to lose the house, but you don't even have a plan. about what happens if that happens, right? So I think it's an important thing to have some kind of plan, a will at least, but also understand about that time delay and all the things that happen when you have a will. So, more people than ever are using trusts to do their planning to help avoid the issues of that delay and that, you don't have to wait to appoint the successor trustee for the court's approval to take place. And that's a big step in dealing with property that's in a trust versus that is being passed by a will. Any questions around that?
I think we have two more. 1 second. Okay, how much do you charge for estate planning consultation? That's number one.
Okay.
And what is the difference between land trust and living trust?
Oh, okay, that's a good question. So we generally charge, so I'll put it to you this way. We have two different, we charge a $450 consultation fee, but we apply it to whatever plan that you hire us for. But if you're coming from Dean or Evan, then we're talking about, we usually charge $250 as a consultation fee. And it's the same thing. We do the same thing. We're going to apply it to whatever it is you hire us for. But you're going to get an hour of my time. You're going to get an hour of speaking to me. And I'm going to, when we finish, you're going to know exactly what you need to do.
And Andrew, how do you speak to them? You speak to them in the office, on Zoom?
Both. I do both.
Okay.
Do both. And also, as far as land trust versus living trust, a land trust is a living trust, right? You create it while you're alive. But land trusts are prevalent in Florida. They're not really prevalent in New York. We don't use land trust in New York.
I haven't heard of them here. Yeah.
There was a time when a lot of people were using land trusts here in New York to hide who owned the house. And it was one of those times when people were, doing a lot of playing around with second two HUDs at the table and all kinds of crazy stuff. But we don't use land trust really here in New York, but it's something that they use in Florida. That helps with the anonymity issue. And it also helps with, I believe that it helps with the homestead that you have down in Florida. So land trust is not something we use here in New York, really. And that, living trust, like I said, are trusts you create while you're alive. And so is, a land trust is technically a living trust.
I have a question for you also. Is that all right?
Go for it.
Yeah, Andrew, is it best, if you have a will or a trust, whichever you ultimately decide, is it best to let all parties involved and maybe parties not involved in your family know where you stand or what you've done?
There's a couple, that's a great question too. I think that, why do kids fight? Why is there fighting when you get through probate, right? Like all of a sudden there's this house that's money, it's always been there and you all got along. Now someone died and now you got to split up this money and there's always fighting, right?
Exactly why I'm asking, because it comes up all the
They
time.
start fighting, right? I think that, in addition to the actual estate planning documents you use, I think that it really is a good idea as the parents or as the person who's doing the planning to leave some kind of note, some kind of letter,
Instructions.
some instruction of why you're doing what you're doing. Because if, the little sister who always needed more help than everybody else, is getting 60% of the estate and the other two are splitting, getting 20% each, there's a reason they're doing that, right? And it's better to, tell your family why it is you're doing what you're doing. Otherwise, when they die with nothing, no instructions, no will, nothing, all of a sudden everybody knows what mom and dad wanted best. They're not necessarily that they're, bad kids, but they're fighting because they all know what mom and dad want to know best, or they're pissed off that they named the little one as the executor when they're the older one. And I don't really want you to be that. I should be that. Why aren't I named the executor? You're named the executor. Mom always liked you more than she liked me.
Well, that's why we put these kind of videos, these webinars together. We want people to have plans to have that conversation, that dialogue that they're not having unfortunately, all of us basically have seen these horror stories where family members who were all together at one point, now they're fighting constantly over something that if they had the conversation, took the time, had the conversation, and they could avoid a lot of this stuff. Example, when my father passed away, pretty much we never had this conversation. Luckily enough, me and my brother, we don't fight over anything much. We're brothers. We fight over stupid stuff. But basically, with this stuff, Dad was closer to my brother than he was to me. So whatever his will was, basically, it was okay with me. And my sisters basically were, it's the will. Whatever he decided, that's what he decided. But not too many families are lucky to where they're not fighting constantly. They're like, you know what? Whatever mom, dad wanted, that's what we're gonna do, and keep it simple.
Yeah.
We're kind of having that conversation with my mom right now. We have a question.
I think someone wants to ask a question. Tanisha.
All right. Tanisha wants to speak, and we also have Shauna wants to ask a question. If you have a will, then create a trust, does it invalidate the will?
Well, invalidate is an interesting word. It does not revoke the will by itself. But usually what happens is in a good plan of dealing with your property using trust, we will also create a will as well. But that will be called a pour over will. So you create all of your planning in your trust. And what you say is that if there's something that has to be probated, because for instance, let's say you have a bank account outside the trust, you don't put it in the trust, and you have a beneficiary named for that. When you die, that is not going through probate, it's not going through the trust, and it's not going through the will, it's going directly to the beneficiary. But if the beneficiary dies before you do, then that bank account that comes into your estate and needs to be probated. So we have a will just in case there is something that needs to be probated. And the way that would work is the terms of the will say, put whatever those assets are into the trust where the rest of my planning is. So the will doesn't technically invalidate anything, but if nothing goes into the will, then you have a will that's not going to do anything anyway, right? So that's another conversation for maybe next time, how we own our property and how owning your property can completely destroy your estate plan if you don't do it the right way.
All right, so I'm going to give Tanisha basically a second to talk. Tanisha, you should be able to talk right now.
Oh, okay, perfect. Thank you so much. I appreciate you guys doing this. This is a conversation that definitely needs to be had. I wish that my clients could see this. I do real estate investing as well. My office is in Long Island, but I do same thing, Nassau, Suffolk, 5 boroughs, things of that nature. So I had a question because I am dealing with a probate situation to where we can't find any heirs. Everyone is dead. There's no will. It's an amazing property in Queens, and we have no idea what to do now. It is in foreclosure, so unfortunately, we were trying to do there's a person that's been residing there for over the 10 years. We were trying to do an adverse possession, but once there's a foreclosure there, you can't really do it. Or maybe Andrew, you can tell me something opposite. So the person that presented it to me has been residing in the property, and she said, listen, he wanted me to have him. I'm like, but there's no paperwork. So again, it's a great property, but we don't know what to do. Like literally, maybe you guys can give some resources on how to research it, or we can partner something outside of the whole. Maybe you guys know, but we're kind of like just stuck, and I hate for the city to just get, you know what I mean? So any suggestions, Andrew, on to resolve situations like this?
The difficult part, Tanisha, is there are sometimes, no matter what, the public administrator is going to get involved, and basically the city's going to take the property, because if you cannot find any heirs at all, and heirs in our world without a will means it goes out to second cousins. Third cousins do not get the $3 million estate, and I've seen that happen. So it only goes out to second cousins, the law of intestacy. And if there are no known heirs, then more likely than not, the public administrator of the county of Queens is going to get involved eventually. And, either that or the bank is going to, move. I don't even know what the bank is going to do, because the point is, it's like you can't name a guardian you can't name, an individual to be the personal representative of an estate that they're not an heir of the person who owned the property. I mean, I have properties that go back, the last deed was 1893,
Wow.
and there's 36 people. It's not, the problem is not that we can't find anybody. There are so many people that are in, that it's ridiculous. But my point is that there are sometimes these properties come along, and I guess that's why there is a public administrator. Because what happens is the public administrator is going to get appointed by the courts to administer this property, and they're going to deal with the foreclosure. There may be a short sale or something, but unfortunately, if you don't have any way of getting someone who is related to the owner, or you can get adverse possession in time, and that's not an easy claim to make, but you can get adverse possession, because who is it open and notorious against? You have to be open and notorious against the true owner in order to have adverse possession. If the last person who owned it is on a deed, died more than 10 years ago, how can you have been adversely possessing it against their interest?
I just want to be mindful of the time. It's 7:24.
Yeah.
So Tanisha, you have our information. Let's talk tomorrow, and then maybe we can do a conference with Andrew. Is that okay?
Yeah, that definitely. Yeah, 100%. That sounds
All right.
great. I
All
just pay for it to go as is. You have it in the chat, the information listed?
If you look on my screen, you'll see the little QR code right there where I'm pointing. Are you on your
Okay.
phone or you're using a computer?
Yeah, I'm using my phone because I just
All right.
left the courthouse. So
Okay, you know what?
Can
In
you-
the email basically will have our information. We'll email you back with our
Great.
information. All right,
Thank
so
you
we have
so much. Thank
no
you.
problem. We have a question from Paul. Hold on one second. All right, so we have a question from Paul. Basically, did I understand you correctly that if you live and die in New York State with a will, that if you owned property in Florida, your heirs have to go through probate, both in Florida, New York, and Florida?
I'm sorry, say that again. Could you read it?
All right, hold on one second. Did I understand you correctly? If you lived and died in New York State with a will, if you owned a property in Florida and your heirs have gone through probate, your heirs have to go through probate from New York and Florida.
That is correct. If you own property in your own name in both of the states, if you lived in New York and died, then you do the probate here in the county in which you died, and then you go with the letters down to Florida and do another probate based upon having the personal representative named here in New York. Or you just put them both into a trust, and then there's no probate at all.
Okay. All right, it's now 7:26. You want to go on to the next subject?
Well, what we have, I think that why don't we deal with the subject that you gentlemen were going to talk about is preparing your house for sale to earn top dollar.
All right.
I
Go
want
for
to
it.
with that, preparing a house is top solid. I just think it's best to keep this more on, on the probate portion of that. I mean,
No problem.
but what I mean by that is when people hire us to sell a home or consult with us to sell a home, every house is different. And I think the way we've actually asked the question, it's preparing the house legally to sell a home. We're not really talking here about, how you clean up a house or how you cut the lawn, anything like that. So we're not talking.
All those things are important also, but the most important thing is getting them legally prepared.
That's a whole nother conversation. That's our face-to-face conversation while you're deciding to put a home on the market. But for now, I think it's learning. I think everybody has to learn about what is the legal situation on a home. If your parents have, or if you have an intention of selling a home in 1, 2, 3 years or any amount of time, now is the time to start preparing that. It's always the time right now to start preparing for that. And it does involve talking to all the parties involved, in my opinion, family members,
David.
the parents.
Hey, Crystal,
Hold on one
man,
second,
you're
guys. I'm
still in
sorry.
your cabin.
I am so
Yeah,
sorry.
this is my last week. Oh, that's
That
awesome.
was that was my next Zoom. Sorry, guys.
All right, so basically what you need to do is talk to your professionals. If you don't have a
Right.
professional on hand, reach out to either myself or Dean, and we have Andrew's information is in the chat room right now. So if you need our information, just reach out to us.
I just wanted to talk, the importance about preparing this for a real estate sale, besides all the headaches, all the personalities involved, all the heartache, all the misunderstandings. And I really mean, that's what happens when we don't prepare for stuff. If we went on a different plane for a minute and we just went even just to money, if a home is ready to sell, you can sell it at top dollar in today's market. Top dollar meaning, you know, conditions great. What's the top dollar for that? Conditions average. What's the top dollar for that? Home needs some work and some improvements, and it's sold as is, and you know, it's more of a cash deal, whatever it might be. That's all based on condition. But when I talk about top dollar, I mean top dollar for the condition right now. If you have a legal problem and you're going to put a home on the market now, and you don't know if it really don't know, like I said before, if it's going to close for 6, 12, or 18 months, you can't determine top dollar right now. Now you're looking at that smaller piece of the pie, which is that person who's sitting at home and ready to wait for you for a year and a half. That person's most likely, you're not going to have competitive bids on the house. You're going to lose top dollar. So besides all the property, I mean, all the income tax that Andrew had talked about, just from real estate value, if you have a home that's ready to sell, when you're selling it, you can get top dollar in that market. Anything less than that, you're not getting top dollar most of the time. So and I can't tell you how much that can cost you, whether that's $10,000, $50,000, or $150,000, but it is some large amount of money.
I just want to go back to what we said originally in the beginning, in the middle, and now. You have to have the conversation. There's no way around this. If you don't have the conversation, it's going to cost you a lot of grief, a lot of white hairs, a lot of gray hairs, whatever, or no hairs, as my two co-hosts have right now. You don't want to be pulling your hairs out. You don't want to have fights with your family, you know, over something that basically, if you had a conversation, it's more drama that you don't need. You're already going through a tough situation dealing with a loved one who just passed away. You don't want to add on to that stress where, okay, well, mom and dad basically didn't leave a will. What do we do? All right, now I'm fighting with my brother, and I'm fighting with my sister, and now my health is compromised. You don't want to put yourself through that. So make sure you have the conversations with your parents, with your loved one, with everybody in your family. You know, have a group conversation, and if you need to do it together, whether it's mom, dad, brother, sister, you all have houses, you own, you know, estates. Have everything done at around the same time. Use the same person. You have Andrew right here, basically. He's a wealth of knowledge. Andrew, how long have you been doing this, by the way?
Only 35 years.
Only 35 years. He's just shy of, you know, whatever, just shy of 40. But anyway, you have a wealth of knowledge right here sitting in front of you. We're going to be doing more of these videos, more content like this. It is recorded, so if you miss anything, you can always go back. But if you want a one-on-one consultation, we're available. All right, the next one is going to be November 2nd at 6:30 to 7:30. So I think you guys want to sign off now, or you want to any last questions?
We're all available between now and November 2nd. Just so
Yeah.
And thank you all very much for even being interested in hearing the conversation. You know,
Yes.
Going up here on a Wednesday night between 6:30 and 7:30. I'm sure you have a bunch of other things you could do, but you know, this is really important stuff. And one thing I will say, and I'll, you know, coming, you know, on top of what Dean said before, you never know when things are going to go sideways in your life. You never know when your health is going to fail suddenly. So, you know, you always think we have until some other time in the future to do the planning. It really makes sense. If it means something to you and if it strikes a note, and then, you know, get on top of mom and dad or get on top of yourself to do the planning now, because you never know what happens tomorrow. We see all kinds of crazy things, and it doesn't, you don't get a 2-minute warning. It doesn't, you know, you don't get a beep, or you don't get a text from God saying, you know, get your house in order. You know, it just happens like that. So,
all right, we have a question from Tanisha. She wants to know if you're doing anything out of state as well.
I know a lot of people in a lot of states. I've been doing this a long time, and I have great colleagues, and I do work with them throughout most of the 50 states.
All right, I'm just typing this in there. All right, I think that's about it. If you guys have any questions, you have Andrew's information. It's in the chat, so feel free to copy that, take a picture of in the chat.
Right?
Yeah, and his website, and there's also a survey. Please take the survey. It's in the chat right now. It's the last thing that was posted in the chat.
He gave you 3 promises, right?
Yes. 3 promises. Please take that. We want to know how we did. Andrew, tell them what the survey says.
The third survey is basically something that we put together so we can figure out what we're doing here, if it makes any sense for us to keep going. So we ask you to rate us on a scale of 1 to 5. 1 means all 3 of us should have just stayed home tonight. And 5 means that we did a great job of giving you some information and it's helpful for you, right? And if you got a couple of chuckles or a couple of laughs along the way and you learned something here tonight, please take your time, fill that out. It gives you the opportunity to tell us whether you want to speak to Dean and Evans or you want to talk to me. And then, we'll reach out to you too, oh, there is the survey.
Okay. Thank you, Tiffany. Tiffany's the operator behind the, she helped put all this stuff together.
Thank you, Tiffany.
Pretty simple to answer. And we appreciate you, telling us what we did well. Even more importantly, telling us what didn't come off so well. And then tell us what you'd like to see in the future as far as topics or things like that. So we're here to help you. So tell us what you need to hear.
Yes. And again, if you need any assistance in real estate and estate planning, you have our information. My QR code is right here. Please scan it on your cell phone, or if you want, screenshot the screen and basically use your device. You'll figure it out basically how to use your device, and you can get my contact information straight to your phone. You have Andrew's information right here in the chat. If you can't get it from the chat, let me know and I'll forward it over to you, and Dean's information as well. Tiffany, you want to say anything? Unmute yourself. Say hello to the audience and goodbye to the audience.
Hello, everyone.
Everyone, this is the lovely Tiffany behind the scenes that made all this possible. So if I can get everybody to give her a round of applause.
Yay.
Yeah, we're giving her a heart. All right, guys. I just what Andrew just did. All right, a round of applause. Got it. All right, guys. We're trying to make trying to be a little, do some little levity. Basically, it's a serious topic, but we want you to come away with some information. We want it to be useful information, and it's a tough conversation to have. But like we said before, we have to have a conversation. On that note, I'm Evan Saint-Gerard.
Graber.
Andrew Jaloza.
And that was Tiffany.
That was Tiffany.
See you soon.
And then she's back.